Just a moment. It was really a rhetorical question.
Okay.
Because it doesn't make sense.
Well, it doesn't.
It doesn't make sense that you would stop talking. Then you really didn't qualify for court-appointed attorney services, did you?
I will figure it out.
This is what you're not going to do. You're not going to talk while I'm talking.
Okay.
I said that when you were before me earlier, but you still seem to think you can talk while I'm talking. Ms. Wall?
He said I needed to say it to
Ms.
him.
Wall, you have to stop talking. That's the way it works. Once more, in my courtroom, you'll be banned. I just wanted to tell you, you are not welcome back. Don't come back to my courtroom. That's it.
All right, now you can leave.
Have a good life.
On the very morning her jury trial is set to begin, the defendant makes a sudden move by dismissing her attorney. She claims the two never had proper communication, a tactic courts have seen many times before, and one often used to stall proceedings at the last minute. Judges are usually quick to recognize this pattern, especially when a case has already been scheduled and prepared. The situation becomes even more serious when you consider the charges involved. The defendant is facing significant felony allegations related to illegal substance possession. Yet her approach suggests she believes the courtroom operates like a complaint desk where decisions can be changed on demand. This casual attitude does little to help her position in a formal legal setting. Things escalate further when her mother steps in from the gallery, attempting to challenge the judge directly. Courtrooms, however, are governed by strict rules of conduct, and interruptions from spectators are not tolerated. The judge responds firmly, making it clear that authority in the courtroom will not be questioned or undermined. This moment turns into a powerful reminder of how seriously courts treat order, procedure, and respect for the legal process. Credit goes to Courtroom TV for capturing this intense exchange. Let's take a closer look at how it all unfolds.
Good morning, Your Honor. Candace Mann on behalf of the people, P80652.
And good morning, Your Honor. Danian Woodson, P68870, on behalf of Ms. Pruitt, who is standing to my left. Ms. Pruitt, please state your name for the record.
Jessica Pruitt.
Good morning, Ms. Mann, Ms. Bratty, and Ms. Pruitt. An issue as to whether the parties want to settle this matter. And we have a jury that is waiting. I understand after having a sidebar discussion with counsel, Ms. Pruitt, that you want to proceed to trial, but you want a new lawyer. Is that right?
That's correct. We have not spoken one time one-on-one about this case. I don't feel like I've been represented at all. I've not been guided. I've been kind of doing it on my own. It's great. I like her and everything, but I need somebody who's going to see what I'm talking about,
Did she review the discovery with you?
She sent it to me in an email. We've never spoke about anything.
You didn't discuss it with her today?
No.
You didn't discuss the offer today?
No, not the offer again. The last offer that she told me, I said no to.
So you're saying that you have not spoken about the case with your attorney this morning?
No, at all, period. Throughout this whole process. I've wrote emails stating my concerns and she's emailed me back, but we've never got to discuss the actual, event of what led up to this.
Well, we've had 1, 2, 3 final conferences. And
That's
you are
correct.
telling me now, after 7 hearings, that you had not spoken to your attorney?
That is
that
correct.
right?
Yes, that is
Does that
correct.
make sense to you, Ms. Pruitt?
Well, I gave the benefit of the doubt. I was
It's
hoping
actually-
that she would surprise me.
No, just a moment.
I don't know.
Just a moment. Just a moment. It was really a rhetorical question.
Okay.
Because it doesn't make sense.
Well, it doesn't.
It doesn't make sense that you would stop talking. It doesn't make sense that you would not have advised the court that you hadn't spoken to your lawyer in 7 hearings.
Right. I
Now,
understand.
what she did or didn't do is a different issue, but I have to find strict necessity to avoid manifest injustice to adjourn or reschedule a jury trial on the day of trial when all of the preparation for your trial is made before today, and there's a jury that is at this moment waiting for me to call them from downstairs. So do you intend to hire an attorney?
I do.
Okay, how long will it take you to do that?
I'm not sure. It won't find one today.
So how long do you think it would take you to engage an attorney?
Maybe a week or so.
I can't have a maybe. You know what your finances look like.
Okay.
How long will it take you?
A week.
If it would take you a week to get an attorney, then you really didn't qualify for court-appointed attorney services, did you?
Well, yes, I did. I will figure it out. I mean, there are ways to to make.
Ms. Pruitt, your case needs to be tried or your case needs to be settled. Either way, you need to have an attorney.
I understand.
And I don't want to set a date for no reason. I need you, and this is my third time asking you now, to give me a date where you can be confident that you can have an attorney of your choice whom you pay for standing beside you. How long will it take you to do that?
A week.
Okay, so we'll come back in a week. We'll schedule the jury trial at that time when you have a new lawyer. And just so you know, Ms. Woodson, I'm going to be looking into the allegations that Ms. Pruitt made today. They're very serious, and I cannot let them go unaddressed, especially because it appears that it is requiring the delay of jury trial. 9 a.m. Make sure that you tell your new attorney, Ms. Pruitt, of the date.
Okay, thank you.
Good morning again, counsel. And Ms. Pruitt, please state your name again for the record, ma'am.
Jessica Pruitt.
Thank you. Thank you for coming back so quickly, Ms. Pruitt. When you left, I had another sidebar discussion with counsel, and I realized, while I was made aware, that I did not give Ms. Wooden an opportunity to respond to your allegations. So I'm going to do that now. Ms. Wooden?
Yes, Your Honor. The court instructed me at sidebar earlier today to call to find out exactly where Ms. Pruitt was, how far away she was, and if she was interested in the offer. At which point I stepped out into the hallway into the conference room, and I called Ms. Pruitt, asked her how far away she was. She said she was on Grand River. I said, Grand River what? She said she was 8 minutes away.
The tension rises quickly when the judge calls everyone back into the courtroom after realizing something important was missed. The judge notes that the defense attorney had not yet been given a fair opportunity to respond, and that decision changes the entire direction of the moment. What follows immediately reshapes the narrative presented earlier. Once given the floor, the attorney delivers a calm but firm response that commands attention. She explains that she spoke directly with the defendant just 10 minutes before the hearing, clearly contradicting the claim that there had been no communication. This single revelation shifts the courtroom's focus and raises serious questions about the accuracy of the defendant's earlier statements. The attorney then provides precise details, listing call times and conversations with clarity and confidence. Each fact is presented methodically, leaving little room for confusion or doubt. It becomes evident that the defendant was not left without guidance, but instead failed to acknowledge the reality of the situation as the facts are laid out. The earlier narrative begins to unravel in real time. The courtroom atmosphere changes as it becomes clear that assumptions made earlier no longer hold up under scrutiny. This moment serves as a reminder that statements made in court carry weight and consequences. Attorneys are obligated to protect their professional integrity, especially when their conduct is questioned publicly. When given the chance to respond, the truth emerges clearly and decisively. What was intended to delay proceedings instead highlights the importance of accountability and honesty within the legal process.
I asked her about the offer again. We discussed it. I explained to her that even if the narcotics were found to be not hers, she's charged with 2 felonies. And based on her behavior in the body cam footage, the resisting and obstruction charge was likely to happen. I also explained to her, when the officers told you to stop, you were supposed to stop. When you don't do that, that is failure to obey a lawful order. When you continue to thrash around, that's resisting. We had that discussion this morning. She said she wanted an attorney who believed in her, at which point I asked her if she wanted a new attorney, and she said yes. At that point, I went out in the hallway. I looked for the prosecutor. I explained to the prosecutor what happened. Shortly after that, Ms. Pruitt came into the courtroom. We asked her approach, and there we are.
So
I'll admit that Ms. Pruitt has changed her phone number. I just got an email from her this morning with the new phone number, and that's the phone number I used to call her when the court instructed me to call her. We have communicated primarily through email because the phone numbers that I have from Ms. Pruitt keep changing. We were supposed to discuss this case on Monday at 2:30. The phone number I had for her then, I didn't receive an answer. That's the same phone number I texted her at this morning at 7:45 to tell her we were in Judge Green's courtroom. At 9 o'clock, I decided to email her to ask her if she received my text. She said no, she thought the court date was at 10. That's when I reminded her. I told her 8:30. That's when she told me about childcare stuff in the email, and that's when she emailed me her new number to say that I can't remember, she said she lost her phone and her phone was broken.
okay, so her allegation that she's never spoken to you about the case is technically accurate, but you've had communication with her via email is what you're saying.
because of the lack of phone communication, because of the inconsistencies of the phone numbers, I have spoken to her before and after every court date. I have also worked with the prosecutor to try to make this offer as favorable as possible for her. We had agreed to not only dismiss the resistant obstruction, but to allow her to plead to 7411 on the possession charge and to do it as a no contest plea.
What's the offer, Ms. Mann?
Your Honor, the offer is for the defendant to plead to a reduced charge of count 1. It would be reduced from controlled substance possession of methamphetamine to attempt possession of methamphetamine, which reduces it from a 10-year felony to a 5-year felony. In exchange, the people are agreeing to dismiss count 2, police officer assaulting, resisting, obstructing, with a sentence agreement of 2 years probation, substance abuse evaluation and treatment as directed, anger management, 40 hours of community service. The defendant is eligible for a sentence under 333.7411, and the people would have no objection. And then any other terms or conditions or fines that would be set by the court.
After hearing from your lawyer, who's an officer of the court, by the way, so I don't need to put her under oath. Anything that she tells me is the equivalent of being under oath because of her status as an attorney. This is what you're not going to do. You're not going to talk while.
The situation becomes even more strained as the defendant repeatedly interrupts the judge, despite clear instructions to stop. Each interruption adds to the tension in the room, and the judge responds directly, pointing out concerns about emotional control and decision-making. The remark is blunt, but it reflects growing frustration with the defendant's behavior during a serious proceeding. This moment is especially striking given what is at stake. The defendant is facing a potential sentence that could carry severe long-term consequences, yet she continues to speak over the magistrate instead of listening carefully. That conduct highlights the very issues that led to additional charges earlier in the case, showing a pattern of resistance rather than cooperation. Throughout the exchange, the judge makes a clear effort to explain the situation and outline a plea agreement that is notably favorable under the circumstances. Rather than focusing on the opportunity being presented, the defendant appears distracted by her own reactions and tone. As a result, the gravity of the offer seems to be lost in the moment. The courtroom dynamic begins to resemble a personal argument rather than a formal legal proceeding, even though the setting demands respect and restraint. Judges are tasked with maintaining order, but patience has limits, especially when repeated interruptions disrupt the process. It is notable that the judge continues to proceed calmly instead of imposing immediate consequences. This exchange raises an important question for viewers. Is the defendant overwhelmed by stress, or does she genuinely struggle to absorb and follow instructions when it matters most? Either way, the moment underscores how critical composure and attention are when navigating the justice system.
I said that when you were before me earlier, but you still seem to think you can talk while I'm talking.
I'm sorry.
It's hard because you need anger and impulse control management. That's why. Control yourself.
Okay.
This offer is exceedingly generous, especially the 7411 component. And although I have never done it, if you go to trial on this and you are convicted, I will be sentencing you with the fact that you had no defense in mind. Do you understand? Okay.
Thank you, Your Honor.
Thank you, Your Honor.
Your Honor, would the court entertain a motion to withdraw?
No, no, because she doesn't have a lawyer right now. But I will at the next hearing.
Okay.
She might under oath.
Ma'am? Call her back here. Ma'am,
And you can stand right up there.
Right here.
Yep.
who are you?
I am Jessica's mother.
And your last name be Pruitt or something else? What's your
Something
name?
else.
What is it?
Walls, Walls.
Thank you. Ms. Walls,
Yes, ma'am.
you're welcome to be in this courtroom anytime that you are in the area, for that matter. This is a public space.
I'm aware.
I understand why your daughter interrupts people
I
while
knew
we're
you were
talking.
going to say that. Yeah.
Yeah,
Go ahead. I'm sorry.
you can't help it, can you?
I can't help defending myself when I feel like my rights are being violated. That's right. I simply was stating a fact that on the board downstairs, it does say 10 o'clock. I didn't take a picture of it, but I just wanted to make you aware of that.
Ms. Wall?
He said I
Ms.
needed
Wall,
to say it to
Ms.
him.
Wall, you have to stop talking. That's the way it works.
I see.
I would like for you to be welcome in this courtroom anytime your daughter is here before court. If you are disruptive once more in my courtroom, you'll be banned. That's why I brought you back tell you that. Do you understand?
I understand.
Thank you.
All right,
Am I able to speak now?
I would
No.
advise you to. To help.
We're stating the charge. It's.
Ms. Wall? Ms. Wall?
So you really want to entertain my motion, Your Honor?
No, I will not. The apple certainly doesn't fall far from the tree. I just wanted to tell you, you are not welcome back. Don't come back to my courtroom. That's it.
All right, now you can leave.
Have a good life.
I advise you not to say anything on the
And
way.
you're welcome to view on YouTube anytime your daughter has a hearing.
Watching that exchange unfold was draining enough on the outside, so it's easy to imagine the level of patience it demanded from the judge. The situation involved not just one difficult participant, but two, a defendant attempting to delay proceedings by questioning her attorney's integrity, and a parent who appeared to believe she could take control of the courtroom from the audience. Together, their behavior reflected a troubling lack of responsibility. What stands out most is how composed the judge remained throughout the ordeal. Despite repeated disruptions and challenges to courtroom order, the judge maintained a steady tone and continued to move the case forward. That level of restraint is notable, especially given how quickly the situation could have escalated under different circumstances. This case also highlights a deeper issue, a disconnect between personal expectations and legal reality. Criminal court is not a place for arguments or emotional posturing. It demands humility, attentiveness, and respect for process. Ignoring that reality often leads to outcomes far worse than the ones already on the table. Rather than helping, the mother's involvement appears to have made matters more difficult for her daughter. Instead of easing the situation, her actions likely reinforced negative impressions and narrowed the defendant's options moving forward. It raises questions about how early guidance and boundaries might have changed the course of events long before this courtroom moment. Now, the defendant is set to return next week to face serious felony charges on her own, without family support present beside her. The stakes remain high, and the margin for error is slim. Whether this leads to incarceration will ultimately depend on the choices made next, but the warning signs are clearly there. That brings us to the final question. Without her mother present and with the court's patience already tested, will the defendant face jail time when she returns? Many viewers believe that outcome is likely. Thank you for watching this breakdown of the hearing, and take care.